Thank you so very much, Rhonda. Ladies and gentlemen, so very much, Rhonda. Ladies and gentlemen, so very. That was an echo. 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 Ladies and gentlemen, we are live. It's Saturday, and this is Lone Wolf's Court Gallery Case and Review. Mountain Maker, thank you so very much. The puppies, thank you. I thank you. Rhonda, I don't know if I said thank you to you also, but I did. I know. I did. I remember. I completely remember. It was absolutely just like 2 minutes ago, and I definitely did not forget what happened 2 minutes ago. Ladies and gentlemen, we have a huge show for you today. I did promise a wrap up to a little bit of some Simpson that we started last night, and ladies and gentlemen, we are going to wrap it up. We're going to watch that first little segment again, and we're going to watch how it ended. And ladies and gentlemen, we got a lot more Simpson than that. But first, I want to explain today's show to you, because today's show is a little special. Today's show starts on Monday, and we're going to meet a Miss Wells. Miss Wells is having a very bad week, ladies and gentlemen. She's stuck in Kansas. She's not from Kansas. She's just traveling through, and she's not having a good week at all. And ladies and gentlemen, we're going to start our show with Miss Wells. And 2 hours later, we're going to end our show with Miss Wells. That's right, ladies and gentlemen. Not only is it a show sandwiched in the story of the case of one person, but it's also about 2.5 hours worth of court cases. Ladies and gentlemen, we got a big one ahead of us today. Buckle in, get you some coffee, get you some refreshments. We got a lot to talk about. We got a lot to do. Hands and feet inside the ride at all times. Ladies and gentlemen, welcome. It is Saturday, and that is bright, and that is not even supposed to be like that. It's in my face. We are here. It is Lone Wolf Live. I am here with all of you. We are ready for some great cases. We're going to start today off in Kansas, and we're going to go from Kansas to Washtenaw County, Michigan. We're going to stay in Washtenaw County, Michigan for a good hour. Then we're going back to Kansas for some more crazy, because when crazy camps in Kansas, it's just on holiday for Michigan, ladies and gentlemen. All of that starts right now. Thank you for coming to Lone Wolf's Weekend Review. It all gets started right now.
What is your name?
Laura Wells.
I have Mr. Cloud here, Judge.
Oh, okay. I was wondering, my notes say that he was in custody, so.
Yeah.
All right, let's take up State of Kansas versus Laura May Wells, case number 25 TR 1720. The state appears by Jared Regier. Miss Wells appears in custody from the Butler County Jail. You're here for a first appearance, Miss Wells. There are 3 charges, all alleged to have occurred on July 14th, 2025 in Butler County, Kansas. Count 1 alleges that you operated a motor vehicle on a public highway in the state of Kansas without having proper proof of insurance. That is no proof of insurance, and that is a Class B non-person misdemeanor. That carries a maximum penalty of 6 months in jail and up to a $1,000 fine. Count 2 alleges you are operating a motor vehicle with an expired tag or registration. First offense, that is an unclassified misdemeanor. That carries a maximum penalty of 30 days in jail and up to a $500 fine. Count 3 alleges that you were driving on the wrong side of a divided highway. That is a traffic infraction, and that carries with it a statutory fine. Do you understand your charges, Miss Wells?
I do.
All
Yes,
right.
sir.
All right. How are you wanting to proceed on your case? Were you wanting to try to maybe visit with an attorney, or have you given it much thought yet?
I am fleeing from a domestic violence type of La Raza. It's a gang. There's been some issues with my ex and my sister. I came into some information about a murder that was committed in Lawton. My sister found out that
Man,
anyways, it's chased me across the state. I was trying to get to a shelter in Topeka. There was an 18-wheeler in front of me.
All right, ma'am, I don't want
Sorry.
you to say anything that might incriminate you. Do you want to consult with an attorney, or you don't have to? If you wanted some time to do that, I would give you that
I just
opportunity.
need to get out of here and get to my boys and get somewhere safe. The officers I spoke with the night before this told me I need to go to the feds and try to get witness protection.
Okay, well, let me go over what your options are today. You can enter a not guilty plea. Bond will be set, and you'll reappear at a later date for court with or without an attorney. You don't have to have an attorney. But if you wish to have one and qualify, I would appoint an attorney for you. You can enter a plea of guilty, which means you're admitting to the charges, and we'd proceed to sentencing. You could enter a no contest plea, which means you're not admitting to the charges. You're just choosing not to contest them. And if the court finds that there's a substantial legal basis, I would then find you guilty. Do you understand your options? Okay, we are taking a record, so you'll need to answer audibly, please.
Yes.
Okay. And knowing those three options, how do you wish to proceed?
What's going to get me back to my son's quickest?
Well, I can't necessarily speculate. Mr. Regier, what city do you live in, Miss Wells?
I was in Norman, but we had to leave there. We went to Dallas. They showed up in Dallas, and so I came here to Kansas. My next step was to go to Harbor House and get plane or bus tickets to somewhere further.
Do you have any ties to Butler County, Kansas?
No,
You're just passing
I'm
through?
just trying to get somewhere safe. Yes, I'm trying to.
All right. Well, here's what would happen. If you entered a not guilty plea, your case would be set over to a court date in September, and the court would then set a bond.
And I
If,
don't bond me out.
pardon?
I don't have anyone to bond me out.
Okay, well, that's something we'd have to discuss. If you entered a guilty or a no contest plea, then you would likely be, assuming the court finds there to be a proper factual basis, you'd be convicted, and we would proceed to sentencing. At that time, you could either receive a jail sentence, though I don't know I can't tell you what I would do. Typically on these types of charges, barring extreme circumstances, there's not mandatory jail time, but there's always a controlling jail sentence that you could be placed on probation from and have to either report to a probation officer here locally, or in some circumstances it's non-reporting, but that would be something that'd have to be taken up if you're sentenced today. So if you wish to consult with an attorney.
That would take longer, right? I would have to wait longer in here.
Well, unless you were able to make bond.
Then just I'll plead guilty. I just need to get out of here and get to my boy.
All right. I don't want you to rush into a decision just because you're needing to get out, because I can't guarantee you what ultimately the sentence would be. You understand that?
The plan was for me to leave the car here and get on a bus. Honestly,
All right. So how are you wanting to proceed?
guilty.
Okay, I'm going to need to, you wish to represent yourself? If you're wanting to represent yourself, I just need to make sure you understand that you have a right to have legal representation on these charges. If you can't afford an attorney, one would be appointed for you. If
That takes
you don't
longer.
have to have an attorney, if you wish to represent yourself, I think the deputy there has a written waiver of counsel form you would need to read over and sign if you wish to represent yourself. That's entirely up to you. And Miss Wells, I understand you're upset and emotional. Are you thinking with a clear mind today? If you want a few minutes to think about this, I've got another case I would take up and then come back to you. Do you wish to need a few minutes to gather yourself?
Think anything's gonna change. I don't know. That officer last night, I was just trying to get to a shelter where we'd be safe.
All right, ma'am, I don't want to get into the facts of the case at this point. I just need to determine how you're wanting to proceed today.
Just
if that's gonna-
proceed.
Okay, in what manner?
I'll sign a waiver.
Okay, deputy, do you have a waiver of counsel?
I do, Your Honor.
All right, could you present that to her? And Miss Wells, I need you to read through that and make sure you understand everything. If you have any questions about it, please let me know.
No.
Just print there, read it, sign there. She signed it, Your Honor.
All right, did you have any questions about the waiver of counsel you just signed, Miss Wells?
No.
And you wish to represent yourself?
Yes.
All right, I just want to make sure you're, other than being emotional and upset, are you thinking with a clear mind today?
Yes.
Are you under the influence of any liquor or intoxicating drugs?
No.
Do you understand that you have a right to a trial on these charges?
I need to get back to my boys as soon as possible. That is the only thing I can.
Ma'am, I need you to answer the questions I'm asking you. Do you understand that you have a right to a trial on these charges?
Yes.
Do you understand at trial, the state would have the burden to prove your guilt beyond a reasonable doubt on each element of the charges?
Yes.
Do you understand that if you wanted to cross-examine the state's witnesses, you would have that right?
Yes.
Do you understand that while you can't be compelled to testify, if you wished to testify on your own behalf, you would have that right?
Yes.
All right, on the no proof of insurance charge, again, I stated that that's a Class B misdemeanor. That carries a maximum penalty of 6 months in jail and up to a $1,000 fine. There is a minimum fine of $300. Do you understand that?
Yes. Can I have like a payment plan for that?
Well, we're not there yet. That's something we'll have to take up if the court accepts the plea and if you're sentenced. All right. Do you understand that in addition to the possible jail sentence, which on the Class B can be up to 6 months, on the unclassified misdemeanor on the expired tag could be up to 30 days. Do you understand that you could be ordered to serve that time?
Please don't do that.
That's an option of the court. Typically on these types of charges, you're not going to receive a jail sentence, but again, ultimately that's an issue that would be taken up at the time of sentencing.
Okay.
And if you're not ordered to serve a jail sentence at this time, you could be placed on probation, which would be with one of our local probation offices, which would require, if it's a reporting probation, for you to meet with a probation officer and follow terms and conditions of probation that we will go over if we get to that point today. Do you understand that?
Yes.
And you understand that you'll be ordered to pay court costs, and if placed on probation, you'd have to pay probation supervision fees. Do you need a few minutes to gather yourself, Miss Wells?
No.
I'm going to give you a few minutes. I'm going to take a brief recess on your case, allow you to compose yourself and go over what we've been discussing. And I'm going to take up a different case and then we'll come back to you, okay? All right, and you're Stephen Cloud, or is it Seven Cloud?
7 Cloud.
All right. We'll go on the record in State of Kansas versus 7 Dontravius Cloud, case number 25 CR 269. State appears by Jared Regier. Mr. Cloud appears in person pro se from the Butler County Judicial Center Zoom location. Looks like you on July 11th failed to appear, then contacted the clerk towards the end of the docket and were set over to today for first appearance. So
Yes,
I'll
sir.
go over your charge with you, Mr. Cloud. There's one count alleging that on April 20th, 2025 in Butler County, Kansas, you did knowingly cause physical contact in a rude, angry, or insulting manner against Alexis Doyle, a person with whom you were involved in a dating relationship or was a family or household member. That's domestic battery, a Class B person misdemeanor. That carries a maximum penalty of 6 months in jail and up to a $1,000 fine. Do you have any questions about what you've been charged with?
No, sir.
All right. How are you wanting to proceed on your case? Are you wanting to visit with an attorney about your options?
Yes.
Okay. Can you afford to hire your own attorney?
No.
If you can't afford to hire an attorney, one would be appointed for you. You wish to apply for court appointed?
Yes.
Okay. Are you currently employed?
No.
How long has it been since you worked?
I don't even know. I'm a full-time student.
You're a student
Yes, sir.
out at the college?
Yes, sir.
Okay. I'll appoint James, or not, actually Darren Patterson to represent you. He's an attorney here in town. I'm going to set your court date for September the 22nd at 8 o'clock in the morning. And that'll be by Zoom, September 22nd at 8 o'clock in the morning.
Yes, sir.
We need to set a bond. Mr. Regier, what's your recommendation?
Your Honor, it would appear that there was an attempt at a first appearance last Friday before Judge Satterfield, at which time the court made a finding that the defendant failed to appear and did enter certain orders concerning bond at that setting.
So a bond's already been posted?
I do not have any information as to whether a bond has successfully been posted, merely that the court has already entered orders as to the amount and type.
Okay, there are no notes on the docket notes or otherwise to indicate a bond's been posted. Do you ever post a bond, Mr. Cloud?
Yes. 1,500.
Okay, does anybody have a copy of that?
I do, but I didn't bring it with me.
Was that an OR bond or did you go through a bondsman?
No, I just got a money order to the jail.
He
Angela,
was in custody.
okay, has a copy of a bond made its way into the filing system?
1 minute, Judge.
When did you,
There,
go ahead,
I'm sorry, Judge, there is no bond in the Odyssey.
okay. So when did you bond out, Mr. Cloud?
Probably like around this morning, like 9, 10.
This morning?
Yes, yes, sir.
Okay, and you had, a money order was sent to the jail?
Yeah, my roommate from school, he brought it up there to come get me out.
Okay, did you meet with a bondsman, or was it a
No.
OR bond? You just signed your own bond? Well,
Yeah, I
it'd
signed
be
my
an
own.
OR bond if you paid $150.
I don't really know. The lady who was booking her, she told my roommate when he called that we can just money order the jail directly, and that's what he did. He brought it up there.
All right. Al, do you guys have any information about the bond situation?
We're calling out there right now to find
Okay.
out.
Judge, if I may, it looks like there was a 2,500 cash or surety bond awarded on from Judge Satterfield, but there's nothing in here that indicates that's been done.
Okay, so she ordered that Friday.
Yes.
Okay, well, obviously you posted it because you're out of jail.
Right.
And you've appeared, so. All right, as a condition of bond, you're not to have contact with Alexis Doyle. Is that going to pose any sort of an issue for you, Mr. Cloud?
No, sir.
Okay, that's no contact in any manner, by phone, by social media, in person, sending somebody else to relay a message. And we set a
Yeah.
court date. I've appointed an attorney. Mr. Regier, anything else we need to do?
Not from the state's perspective, Your Honor.
All right, Mr. Cloud, do you have any questions?
And how long is the no contact?
Until the case has been disposed of, or sometimes upon motion of the judge who's assigned to the case, that order can be modified or lifted, but that'll remain in place until such time as the judge in your case is Judge Webster, if she would modify that in some manner. So you might visit with Mr. Patterson about any options you might have regarding the bond.
Yes, sir.
Any other questions?
And you said just talk to the attorney you appointed about any other things about the no contact?
He'll be able to discuss all of the aspects of your case with you.
All right.
And it'd be a good idea when you got done here today, his office is across the street. Pop in there and give him your contact information so he'll know how to get a hold of you.
Yes, sir.
I'm not saying he'd be able to meet with you today, but you can at least give him all of your contact information.
I got you.
Al, did you have a question?
Yeah, Your Honor, they said it was a $1,500 cash or surety bond.
Okay. All
And
right,
they had
very good. All right, if there's nothing further then, we'll be in recess, and Mr. Cloud, you are excused at this time. Have a good day. All right, we'll go back on the record in state of Kansas versus Laura Wells, same appearances as before. Miss Wells, are you wanting to continue to proceed with this attempted plea?
Yes.
Okay. And again, you're of sound mind and are emotionally able to move on?
Yes, sir.
All right. I've gone over your trial rights with you, the possible penalties that can be imposed. Do you have any questions about anything we've discussed so far?
Yes, sir.
I'm sorry, that was no?
No, sir.
Okay. Has anybody made any threats or promises to get you to enter into a plea today?
No.
Is your plea being made freely and voluntarily of your own free will?
Yes.
Are you entering a guilty plea because you are in fact guilty of each of these three offenses? Okay, was that a yes?
Yes.
Okay, I'll need to go through each one of these charges individually. When you enter a guilty plea, you're saying you did in fact commit what you have been charged with. What makes you guilty of no proof of insurance?
I couldn't afford insurance. I was fleeing for my life, though. That vehicle was my only means to getting me and the boys to safety. But I did not have insurance.
All right, so did that occur? Where were you pulled over?
In El Dorado, I think. I
In
had
town or outside of town?
I'd had several cars following me. My sense of direction was a little off. I was scared. I'm not exactly sure where.
And this occurred earlier today on July 14th?
I called the police myself when it happened. I had stopped in El Dorado right before it happened and called the police and told them that there was 2 cars following me. And I was concerned about driving to Topeka in the dark. But the boys and I had been in the car since the day before, trying to find a shelter to go to. So I decided to go ahead and push through and try to get there.
Okay, Mr. Regier, can you, for purposes of a factual basis, tell me where this stop occurred?
I actually called myself. I wasn't pulled over.
Your Honor, as a preliminary matter, is the court find that the defendant has in fact successfully waived her right to counsel on the record?
Yes.
Very good, Your Honor. Your Honor, pursuant to the ticket in this matter, the ticket appears to refer to a stop occurring on I-35 southbound at milepost 76. The state's understanding is that is within Butler County boundaries, specifically on the northeast side of El Dorado, also in close proximity to El Dorado Lake. The ticket further refers to a date of occurrence of July 14, 2025.
All right, thank you. All right, what makes you guilty of expired tag or registration?
In Oklahoma, it costs quite a bit to get your car tagged. I think mine at the current right now, it's about $12.50. I'm not working. I've been running from this particular issue for a few months, so I didn't have money to get it tagged.
Okay, so you've admitted that you didn't have valid insurance or a current tag or registration on the vehicle. Is that correct?
Sir,
Okay, and then what makes you guilty of driving on the wrong side of a divided highway?
I did in fact turn around. The 18-wheeler that was in front of me turned his lights off and stopped in the middle of the road and turned to the side. And there was 3 cars approaching behind me very fast. I was very concerned that it was an ambush. So I did turn my car around and called 911.
Mr. Regier, are there any police reports that would corroborate any of this information that Miss Wells has discussed as part of what was occurring apparently in the early morning hours today?
Your Honor, besides the ticket, I am showing another report in my file. Although based off of the statements made by the defendant on the record, the state would note on the record that it does have certain concerns under KSA 223302. However, if the court is prepared to proceed, I can certainly supplement the record as needed.
What's the statute you just cited?
KSA 223302, Your Honor.
Station.
Ms. Wells, I'm having concerns about your level of competency here today.
I'm competent, Your Honor. This can be backed up. I have a criminal defense attorney in Oklahoma City that can back up what has been going on. I also, in Emporia, there is an officer there who can back up the fact that I was being followed. They actually escorted me to the county line the night before. I had been fleeing this from Texas. They in fact validated that there was vehicles following me. He sent his officers out to see. This can all be confirmed and validated. I've got the attorney's number.
I think what I'm going to do, I'm going to halt further proceedings on any sort of a plea. The court has not accepted a plea at this point. And I'm going to set this over to the expedited misdemeanor control docket for July 18th at 1:30 in front of Judge Lee. I'm going to appoint Darren Patterson to represent you. He's an attorney here in town.
Please don't make me sit in here any longer, sir.
I have concerns about your competency and your safety based on what you've been telling the court today. So that's just a few days from now, you'll be back in front of a judge with an attorney.
What about my boys? They've been through so much.
Well,
Oh, my babies.
so we need to establish some sort of a bond. Mr. Regier, what would be the state's request?
Your Honor, in this matter, the state would be requesting a cash or surety bond of the amount of at least $3,000. Based off of statements made on the record by the defendant, it would appear this is a defendant with little to no, if any, ties to Butler County, as well as based off the defendant's statements concerning her acts of travel recently. The state does consider this defendant a significant flight risk. Additionally, it is the state's understanding that this is a defendant with history of convictions out of a jurisdiction well outside the state of Kansas that the state considers relevant. Therefore, the state does respectfully submit that $3,000 cash or surety was appropriate.
Please, I have never been in trouble in my life. I'm not a criminal. I am just trying to get to safety. This organization, La Raza, feels like I have snitched. I went to the police about the murder, and my ex and sister are both heavily involved in them. I am just trying to get my sons and I to a safe location. I'm not trying to run from anybody or cause any trouble. We have been through so much.
I'm gonna set bond at $5,000 cash or surety. As a condition of bond, you're not to leave the state of Kansas.
I can't bond out.
The hearing on July 18th at 1:30 will be by Zoom. Again, you'll have an attorney here with you. All right, Mr. Regier, is there anything else we need to do today on this case?
Not from the state's perspective, Your Honor.
All right, Ms. Wells, do you have any questions?
I'm begging y'all not to do this.
Well, I think it's for your best interest, Ms. Wells. I have concerns about your competency and your safety. So if there's nothing further, we'll be in recess. You are excused, Ms. Wells. All right, Mr. Regier, have I covered everything on your list?
It would appear so, Your Honor.
All right, thank you very much.
Court does call the case of the people versus Lugene Campbell.
Good afternoon, Assistant Public Defender Lauren Perry on behalf of Mr. Campbell. Mr. Campbell, state your name for the record,
Lugene
please.
Campbell Jr. Okay. You feel good now? All right.
The good news is we haven't agreed.
Okay, see? It all works. You need to thank her.
So I'm gonna add count two of double parking. He's gonna be responsible for that. Hopefully he'll go to the driver's license appeal and be successful.
All right. Thank you. Thank you, prosecutor. Mr. Campbell, do you admit responsibility to the fact that on April 20th, 2025, location of Gulfside Road in Pittsfield Township, Washington County, State of Michigan, that you double parked a motor vehicle? Yes, Your Honor. All right, Kurt will accept that admission to count two. Count one is dismissed. Fines and costs of $180. Now, we don't need to pass the plate, do we?
No, sir.
No, I'm just kidding.
Sir, Your Honor, can you give me 90 days? I got to send my daughter to college.
Oh, where's she going?
She going to Ohio State.
Oh.
Sorry.
You know, I don't know. Prayers are gonna help. She's going to Ohio State?
Yes.
Freshman?
Yes.
Oh, that's exciting.
Yes.
Okay, why did she pick Ohio State?
You need to talk to her. A lot of my hands.
Well, that's good though. She's going to school, right?
Yes.
So
Yes,
that's the important part. You know, she wanted to go to a second-rate school. That's fine. No. That's her business. Okay. So you need
Need at least 90 days because I got to work on her.
Pardon?
My daughter. Need at least 90 days.
Is this your daughter that's going?
No, that's my wife.
That's your wife?
Yes.
Okay. So you say you need 90 days. Why? Because you got to pay for it?
Yes.
Yeah. Okay, all right. Anybody that's had kids and send them to school, we knew what that was. You just need to tell me.
Yes.
All right, let's do this.
Thank you, Honor.
Ma'am, I trust you. If I give you a date in the future, you're gonna make sure he pays it? I don't trust you. I do. Get it paid before the end of the year, the
Thank you.
31st, okay? That way, that'll give you some breathing room.
I appreciate it.
All right, congratulations to your daughter and congratulations to you too for, creating that product, nurturing it and making sure that she can go to school. To me, that's beautiful.
Thank you, Honor.
And you do have a wonderful wife. I do not know her, but when everything was going on that was going on, I could see, and I meant it. I said it kind of as a joke that she was sitting up there praying. She knew you had to come up here. And then when the hands came up, I said, oh. But I could feel it. All right. You guys take care of each other.
Thank you, Honor.
Take care, man.
Thanks.
Court does call the case, People versus Mitchell Carr.
Conrad Siller on behalf of Pittsfield Township.
I'm sorry, Your Honor, this is a show cause.
They were both ordered to show cause. Your name?
Mitchell Carr, C-A-R.
Okay. All right. So you are before the court on 2 misdemeanor citations. It looks like 2, or are they the same one? 2 misdemeanor citations. The first one being in the case ending in 0671 is the charge of driving while license suspended, denied, and or revoked. That is a misdemeanor. You understand the nature of that charge, sir?
Yes, sir.
All right, and that's alleged to have occurred on May 25th, 2025 at the location of Carpenter Road in Pittsfield Township. That's a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs, and your vehicle could be subject to mobilization. You understand that, sir? Yes?
Yes, sir.
All right. And then the other charge, which is contained in case ending in 0673, is the charge of possession of drug paraphernalia. That is alleged to have occurred also on that same date and at that same location of Carpenter Road in Pittsfield Township. You understand that charge, sir?
Yes.
That's a misdemeanor punishable by up to 90 days, $500 fine plus court costs. You understand that, sir?
Yes.
All right. So, sir, with reference to these, the first question I have is, do you wish to be represented by an attorney on this?
Yes, the way this all came about was I was missing, I wasn't getting a lot of mail in my house. I was missing like my DTE bill and normal bills. And I just retired too, and I didn't receive my retirement check, so I didn't know what was going on. But I received a certified letter that I had to go to the post office to pick up. And that's when I discovered I had a bunch of mail there. So it wasn't undeliverable. And then I had some neighbors in the neighborhood bringing me some of my mail.
Gotcha.
I think it was a mail carrier. They've got a different one since then.
Okay, you're good. Don't worry. You're okay. We got you in here. We issued a show cause. You showed up. So,
Right.
So if you want to be represented by an attorney?
Yes.
All right. Just public defender cases.
Yeah, we waive, Assistant Public Defender Lauren Perny on behalf of Mr. Carr will waive formal reading, stand mute to the charges, and request another pretrial date.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea on defendant's behalf. Pretrial in these matters will be adjourned to August 6th, 2025, 9 a.m.
Here.
Bond in each of these cases will be set as $5,000 personal recognizance bond. All other standard conditions, including no assault behavior, possession of any weapons, no alcohol, recreational marijuana, or any illegal drugs. You understand that, sir?
Yes.
And sir, if I were to send you over for a drug test right now, would you come back clean?
Yes.
You would?
Yeah. I've since discovered a piece of drug paraphernalia. I've recently discovered where that came from. I'm not a very happy person about it.
Okay. All right. I'll let you deal with your attorney on that. I'm not going to send it at this point. Okay.
Right here.
Thank you.
Thank you.
Thank you.
Court calls the case People versus Esther Chinula.
Give me on that.
Conrad Siller on behalf
I'll
of
give you a
Pittsfield
call.
Township.
Okay. Thank
Public
you.
Defender Natalie Pate with on behalf of Ms. Chinula, who is present via Zoom. Ma'am, can you please unmute and state your name for the court? Yeah, he's muted.
Hello.
Hello.
Hello, state your name, please.
My name is Esther Chinula.
Okay, thank you. She's here.
Thank you, Your Honor. It's my understanding that Ms. Chinula has taken the written test, however, she still needs to take the road test. So I'm asking for an adjournment so she could get that done to get her license.
Okay, do you have the road test scheduled yet, Ms. Chinula?
Not yet. I'll schedule it on Monday. Tomorrow.
Tomorrow.
Yeah.
You gonna pass it?
Yeah, I pass it and then I have to schedule for the road test. So I was talking to the
Okay.
coach. The coach is going to come back to me tomorrow.
Okay.
Yeah.
So I'll adjourn this out to August 6, 2025, 9 a.m. All right? Thank you, ma'am.
Okay. Thank you so much, Your Honor. Thank you so
You're
much,
welcome.
ma'am.
You're so welcome. Thank you, Ms. Chinula.
Thank you.
You're welcome. Court does call the case of the people versus Brandon Windgate. Take care, sir.
Conrad Silver on behalf of Pittsfield Township.
Good afternoon, Assistant Public Defender. Lauren.
Good afternoon, Your Honors. Sunny Viswanath on behalf of Mr. Wingate. Mr. Wingate, can you state your name for the record?
Brandon Wingate.
Your Honor,
Okay,
may I- go
They
ahead.
did file a substitution. Okay, go ahead.
Your Honor, may I have a breakout room with the city attorney?
No, that's not how we do it here.
He's approved for double parking. He has a valid license. Do you want to admit that?
Are we okay with that?
Yes.
Yes, we're ready to proceed, Your Honor.
You're right.
We're gonna move it. Count to double parking. If you accept admission, move to dismiss original charge.
Agreed.
All right, Mr. Wingate,
Yes.
do you admit responsibility to the fact that on May 30th, 2025, at the location in Pittsfield Township of Carpenter Road, Washington County, State of Michigan, that you double parked a motor vehicle?
Yes.
All right, court will accept that admission to count two. Count one is dismissed. Fines and costs of $180. When can you get that paid, sir?
In 10 days. I can get it paid today. I can get it paid today.
What happened? You all of a sudden, what, you looked down and found money? Or how come you were asking me 10 days and then all of a sudden you had it?
Because I want to get it out the way. It's better if I can wait 10 days, but sorry.
Go ahead, I'm listening.
Yeah, it's better if I can wait 10 days, honestly. But I will be borrowing from a pretty late bill to do so, but 10 days would be very appreciated.
Mr. Wingate. Mr. Wingate, do you need a little bit of time to get it paid?
Yeah, I do.
That's gonna make your life easier?
It would.
Am I here to make his life easier? Or mine? I should? No? Yeah, he looks like a good guy. Here's what we'll do. Mr. Wingate, get it paid by July 31st. Will that give you enough time?
Yes, it would. Thank you.
All you gotta do is ask. But that's okay. We got it. July 31st. Thank you, sir. Thank you, counsel.
Greatly appreciate it, Your Honor.
Take care.
Take care.
Court calls the case of the people versus Nehemiah Gregory.
Good afternoon, Assistant Public Defender Lauren Perry on behalf of Mr. Gregory. Mr. Gregory, please state your name for the record.
Nehemiah Gregory.
Your Honor, we are asking if you could tell us if he has a valid license. He took his test the 14th, so this Monday. They didn't give him a temporary license, however, so he waited a way to prove it essentially until he gets his plastic one.
They what?
He has sorry, I lost my train of thought. He took the test on Monday. He said his license is now valid because of that.
Monday.
The 14th.
Okay, so as I'm looking at this, this tells me that his license is valid, but this was received on the 10th, saying he was valid. Did you want to know? Thank you. Anticipating. Just ran it, he's valid. He's got a license.
Maybe I'm mixing up my days. Am I mixing up my days, Mr. Gregory? Did you take your test this week?
Yeah, so I took it Tuesday, yesterday.
That gets worse. So all I know is we just ran him, he's valid.
Okay, I'll take it.
Oh, no, I'm all worried. All right, so in case 0632, I'm gonna add count to the double parking.
In 3, okay.
0632. Would be admission to double parking in that case. Of course, the original case of original count would be dismissed. And the other case, 1565, would be dismissed.
Got it. Okay, Mr. Gregory, do you admit responsibility to the fact that on May 19, 2025, Packard Road in Pittsfield Township, Washington County, State of Michigan, that you double parked the motor vehicle?
Yes.
All right. Court will accept that admission to count 2, count 1, and the case ending in 1565 are dismissed. Fines and cost of $180. When can you get that paid?
Tomorrow.
Okay. Pay that by the what is that, the 18th? Pay it by this Friday, the 18th.
Okay.
Okay. Thank you,
Yep.
sir.
Yep. Thank you.
Court calls the case People versus Yuli Walker.
This is an arraignment and pretrial. He's at the access point. I don't know what they're doing.
Okay.
Yes, sir.
Comes the access point. Why is he at the access point?
He's just getting zoomed.
Yeah, but why doesn't he just come down to the court?
That's a really good question.
I know.
I'm here to courthouse, Your Honor.
Huh?
I'm here.
Yeah, he was sitting in here, I think, because I saw him.
Yes.
Because he's got, I think, a New York Nets jersey on.
Yes, I'm right here, Your Honor. Your Honor.
Yeah, but why are you in that room and not down in the courtroom?
Because I didn't know I was supposed to be, and they told me I was supposed to be on Zoom. So I came in here.
Sir, walk out of that room, come down to the courtroom, all the way at the end, courtroom C.
Okay, okay.
Yeah, take your head off when you come inside. I'll pass that one. Court does call the case People versus Mark Williams.
Good afternoon, this is the Public Defender Lauren Perry on behalf of Mr. Williams. Your Honor, Mr. Schiller graciously extended double parking with Mr. Williams, given that he has made efforts to get his license. If you can remember, he's the man with the Camaro and the Mustang, et cetera.
And a third vehicle. Corvette. Camaro, Mustang, Corvette.
Yes.
But he is trying in the circuit court. He hired an attorney, so he's made significant efforts. And he did give me permission to admit on his behalf.
So, Your Honor, I move that count to double parking, to accept the admission of Ms. Branning, and we are all set.
Ms. Perry, on behalf of your client, do you admit responsibility to the fact that on March 18, 2017, at a location in Pittsfield Township, Washington, Michigan Avenue in Pittsfield Township, that he did double park a motor vehicle?
I do.
Court will accept that admission to count 2. Count 1 is dismissed. Fines and cost of $180.
He is asking for 8 weeks. He's gotta pay that attorney, I guess.
It's 2 months.
Something like that.
So I don't know, why did she say 8 weeks?
It sounds better than 2 months.
Oh,
I think it does, doesn't it?
August 29th. Not quite the number of weeks, but get it done. Do we have it all?
Not yet.
Okay.
Yeah.
So I can't do anything. She had cases, right?
Yeah.
Oh, right. Court recalls the case, People versus Christina Evans.
Conrad Solar on behalf of Dixon Township.
Good afternoon, Assistant Public Defender Laura appearing on behalf of Miss Evans. Miss Evans, please state your name.
She was there.
She dropped and now she's.
Hello.
Hello, Miss Evans.
Hi, can you guys see me now?
Yes, we can see you. We can hear you and we can see you.
Okay, sorry about that.
Because she was upset we couldn't see her. I can see you. I said, and then after she got finished yelling at me, then she dropped. I didn't know where she went.
Oh no, it was a Wi-Fi. I wasn't yelling.
Oh, you weren't yelling. Your Wi-Fi just gets loud. Okay.
Yes.
No. All right. What are we doing?
So Miss Evans said the last update I heard from her is that she took her road test. Is your license valid now, Miss Evans?
Okay, so I have to take my test again. I am scheduled for tomorrow at 9:20 to retake my test.
The road test?
So I haven't gotten to the road test yet. I'm taking. They made me retake everything. So I'm taking a book test on the computer now. But I failed the first one, but I have a retake for tomorrow at 9:20.
Okay. I got you. So you didn't pass the first time. You got to get the second time. And then you can take the road test then. Okay. So you're
Yes.
taking that tomorrow.
At
All
9:20.
right. 9:20. Isn't that when the other lady's taking?
Yeah, it was. It was 9:20.
Uh-oh. I go up there to have a 14A1 party at the same time. I'll adjourn your matter out August 6, 2025.
Okay, thank you.
9 a.m. Okay?
Thank you.
Thank you. Good luck tomorrow on your test.
Thank you.
Case People versus Yuli Walker.
Conrad Solar on behalf of Dixon Township.
What's state your name?
Yuli Walker.
Sir, you are before the court on charge of drug paraphernalia that is alleged to have taken place on June 19, 2025, Carpenter Road in Pittsfield Township. Do you understand what you're charged with?
Yes, sir. I do.
Misdemeanor punishable by up to 90 days, $500 fine plus court costs. You understand that?
Yes, sir.
Do you wish to be represented by an attorney?
I can't be, yes.
Pardon?
Yes.
Public defender case.
Good afternoon, Assistant Public Defender Lauren Perry on behalf of the defendant. We waive further reading standing to the charges and ask for another pretrial date, please.
Defendant him wait formal reading. The court will enter not guilty plea. Pretrial in this matter will be set for August 6, 2025, 9 a.m. Esteban, sir, if I sent you over for a drug test, you gonna pass?
No.
Didn't think so. What's gonna come up? Lee?
Same thing.
Maybe. Huh?
Same thing. Okay.
Cocaine?
Yes, yes, yes.
All right,
Yes,
let's go on.
Well, Your Honor, now that he's represented by counsel, if he is continuing to use, we can get him into some kind of treatment program.
When's the last time you used?
It's been about a week, 2 weeks. Maybe 2 weeks.
Okay, hang on. Let me just tell you something. Now, I'm talking to you.
Yes.
See, you can't even focus on me. So the worst thing you can do is lie to me.
Yes, sir.
So I'm gonna give you another shot.
Okay.
When's the last time you used?
It has been 3 days.
Pardon?
3 days.
3 days?
Yes.
You didn't have any today?
No.
What are you
I
been
was asleep all
taking
day.
today?
Nothing.
You are so, yeah.
I mean,
I don't have a date before that I'm doing, but we'd have to probably give a bond review or sometime.
You don't have to take.
That's fine. I'm gonna set his bond at $10,000. 10% bond. Although the standard conditions, including no assaultive behavior. Or possession of weapons.
That's probably not gonna give you a bond. You'd have to pay. Try to get you in this treatment program. You're going to do?
I'm going to a program in California.
Are you in treatment?
I'm through VA. I'm through VA. I'll set up for a
Are you living here?
I live here, yes.
Is it online?
No, I can be insurance. Something to travel. I'm going through the eviction right now, so I do my housing, move my housing. At the same time.
How are you going to do your program in California?
Because I'm going through insurance.
Are you moving to California?
No, it's a 2 month program.
So my client is telling me that he is engaged in substance abuse treatment through the VA. He has insurance.
What
through
branch
the
of the military? I retired from the Army. I retired at a young age. And so I'm going through VA. I went to a program in California. And so I'm going through another program now. But I'm waiting. I'm in the process of moving at the same time today.
Sir, here's my problem. Right now, I'm not convinced that you're focused on me.
I'm focused on you.
No, hold on.
I'm let you talk.
I think you've been using a whole lot more than just the last three days ago. Because I don't, for example, understand why you came into the courtroom. You were in here. And then knowing that court was going on, and then you headed down the hallway to get on Zoom. So I didn't, hold on. I don't even, bless you. I don't even begin to understand that. Then you tried not to just tell me the truth when I asked when the last time you used was. And had to admonish you, and you finally told me the truth, but I don't even think that's the truth.
You gonna say something else?
So here's what I'm gonna do. There's to be no use of alcohol, recreational marijuana, or any illegal drug. At this point, I'll give him a chance to bond out. I'll reconsider it, Ms. Perroni, if you get some documentation regarding some type of treatment, but at this time, the defendant's bond is set at 10,000. I'll give a 10% privilege on that, but defendant's remanded. You need to go with my bailiff, sir.
Can I say something else?
You need to go with my bailiff. Hang on a second. I gotta do this one. Well, I can't do this one.
That is correct. I don't have that information for you just yet.
You don't have this information. Court does call the case of recall. I'm out. Court does call the case of the people versus Tasha Beavers.
Conrad Silver on deck.
Good afternoon, Assistant Public Defender Lauren Perroni on behalf of Ms. Beavers. Please state your name for the record.
Tasha Beavers. All right. We just sent over the results. Did you see them?
I am reviewing them. So I see
The cocaine is negative at this point.
the cocaine is negative.
There were 2 tests. She took one yesterday
Okay, so that's why
and I
there's
had
2.
one today.
Okay. So yeah, I guess both say,
The cocaine is no longer in her system at this point.
negative.
Yes. What are you doing on this case?
Well, Your Honor, the offer is to dismiss it if she completes treatment. She is engaged in treatment. So we were gonna ask, did you want to adjourn it to see if you complete the program?
I haven't even, I just started it yesterday, but I'm not doing any drugs. And I did jail time. I did everything you guys asked me to do. And I'm wondering, why do I have to keep going through this?
I've never seen test results like this
What do you mean?
with the negatives and the positives and
No, I'm assuming that she might have a prescription for the opiates, but I don't know.
She does. She did.
And then for the benzos, that she has one.
And she did provide that to community corrections, which she
Okay.
at her intake.
And
they detoxed me on my own medicine.
I will say, Your Honor, that she did admit to a bond violation
Oh, I
prior
remember.
to, prior to,
Fourth,
right.
June 4th, she admitted to the violation regarding the cocaine.
And she did do time.
Yes, she did.
She has, again, said that she has not used since being released from jail.
I haven't used.
I don't know if at this point her system has now flushed the cocaine.
Okay, let me just explain something. She last tested positive on the 8th for cocaine. If she stopped using, I would not expect to see it in her system today or yesterday, which we don't. I will tell you my honest opinion is that she stopped using, went and took a test, which is the other test that she had, came back clean, and now these tests are coming back clean because she's not using. I think it's really as simple as that. I think she was, and now she's not.
Well, Your Honor, given the fact that she's now has had 2 tests positive, she did have that negative test.
Yeah, those are back-to-back days. I mean, that's.
Yeah.
You're right. I mean, there are 2, but.
The negative test granted at another location back from the 9th that she did provide me a copy of, and we can provide that to the court as well.
Yeah, but I don't, so, okay, let's just be real clear about this. From May 21st through July 8th, she tested positive for cocaine. This test and these 2 tests are the first tests since she's been doing this that she did not test positive for cocaine.
Yes. At community, yeah. I guess Ms. Beavers' position is that she took a test somewhere else and it was negative. Understanding that.
That happens if you stop using for a moment. I mean, I'm not entirely surprised. I mean, she knew what she had to do. She had to stop. She didn't before.
But I guess my ask is, given that now these tests are negative, she is enrolled in CCOP at our community corrections, that we just adjourn it out.
Yeah, because New Home Division said I did not qualify. So I went over there on my own, and I've been going everywhere, and I'm not doing no drugs. I don't know what else to tell you guys.
What do you wish me to do with the case?
I'm just asking to adjourn it out and to have her keep going to the CCOP program.
Why do I have to do that?
August 6, 2025, 9 a.m. Her bond at this point will continue. And ma'am, I'm just going to give you an admonishment. I'm not going to get into the details of it. I read into the record the horrendous language that you use to the folks over at Community Corrections. I then sent you over today to take the test and apologize. I got a report of your so-called apology. It wasn't an apology. It just wasn't. Not for all the stuff you said.
I did.
No, listen to me. They do not deserve that. When they're testing you, they are following my order. So if you got something to say about it and you think it's MF this and all that stuff, then you come tell me and let's see how that works out. But I'm going to let you know you're going to continue to test it. And if I hear even an inkling that you have said anything disrespectful to those fine folks over at Community Corrections, I can guarantee you one thing. And the thing that I will guarantee to you is my wrath, and you will sit in jail. They don't deserve it, and they're not going to have to put up with it. Not if I can help it. At this time, your bond will continue. We'll see you on the 6th. Thank you. That's it?
Yeah.
I was just starting to have fun. All right, 14 days, stands adjourned. Let's call the case of Lynn King versus Kia McDonald. Thank you, counsel.
Thank you.
Good weekend. Yeah. Well, they may be able to stand it. I think they can. They'll stand it for it. All right.
Your Honor, this is Lincoln.
All right.
Nakaya McDonald.
All right. Take your hands back. There you go. All right. All right, where are we on this case? There was 1760 owed the last time that we were here.
Yes.
We talked about the late fee issue. Were you guys able to work something out?
She paid July rent after like several days, 11th of this month. So her balance is reduced to $865.86. That is include May, June, and July late fees. And the utility.
So this amount is May, June, and July late fees?
Yes.
Okay, and go ahead. And what else?
There's a $70.86 utility, and before she set up her DTE account, so I paid for her.
$70.80?
Yeah, 86 cents.
86 cents. And then what else?
And
Anything else?
55 court fee.
For the court fee?
Yes.
All right. So if I take this 55 and if I take the $70, $55, and then the 86 cents, but if I do that, so of this 865, 86, all the rest of that are late fees.
Yes. It's on the lease. $5 per day is the lease.
Oh, I know.
Yeah.
I think. Do you have that broken down so how many, hang on, give me 865. Well, I can do it myself, that's okay. 65, 125, 04. So I have $740 in late fees. So how many months is that?
That's from May. She hasn't paid late fee since.
Hold on a second. I'm trying to, I don't, I'm not asking what she didn't pay.
Okay.
I'm saying this $740 are late fees for how many months?
3 months. Actually, July
Hold
she
on.
paid it on 11th. That's earlier. So that's only count for 10 days. In July for July rent only.
I don't know what that meant.
Like May, she didn't pay late fee.
Hold on a second.
Okay.
So for July, her late fee was only $50.
Yes, July, there's a $50 plus 5 days. So on the lease, it says if after 5 days she didn't pay, or whoever the tenants, well, $50 initial fee, and the plus 5 days times 5. So that's $75 on July before she paid. Then $50 on, plus 5 days per day. On June rent, that was $170. And May rent was the most.
That all sounds really nice and pretty, but listen, I'm trying to figure out that even if, give me 740 minus 75.
665.
So if I take July out of the picture.
Yeah.
And it's $75. She has paid for 2 months. You want to charge her $665 in late fees.
For the May rent.
How much is her rent?
The rent is $520 on her portion.
Right. So effectively, just bear with me here. You want to charge her about, my math is right, about a month and a quarter of what she pays for rent as late fees.
Yes, Your Honor. Yeah, because I really encourage tenants.
Hang on a second.
Yeah.
I understand you said yes, Your Honor. Does something sound wrong to you about that? That was a question.
I calculated based on the lease.
Okay.
Day by day.
I know what you did. I'll say it again. You're charging her $665 in late fee. Her rent is somewhere around, her portion is around $500.
$520, yeah.
You're going to charge her for 2 months late fees that are the equivalent of a month and a quarter of her rent. Now comes my question. Does something sound wrong to you about that?
Well, I just tried my best to encourage tenants to pay on the time because it's irregular, totally out of my control.
Oh, I don't think it's out of your control.
Because I need tenants to follow the lease to pay so that I book on time. But if it's irregular, I'm totally, because her sheet has been individual.
Your late fees on any lease, the law is that they have to be in some way related to the cost of collecting rent. It also indicates that they cannot be liquidated damages. This sounds a whole lot more like liquidated damages than it does related to the cost of collection of rent.
I'll take your advice, Your Honor.
Oh, you don't take my advice. I don't give advice. I give orders. So I understand she may have been late. I get that. But I also understand that you would have to show me that somehow or another you spent $5 every day trying to collect her rent.
Yes.
Outside of the fact that, mind you, a portion of her rent you got already
Yes.
because you get it through the subsidy.
Yeah.
So
that's right.
So that's the other part that's silly about this. You're charging her $5 a day, but part of her rent is guaranteed to you. Oh, is it a HUD subsidy you have, ma'am? Then I think also the $5 a day per their lease is illegal. You can't charge it.
I think that's the lowest charge on the late fee, as I know, from the real estate market. I've talked to the Ann Arbor Real Estate Society and the society. They provided this number for me.
Okay, here's what I'm going to do, because you're not listening to me. I'm going to send you two out. You go out, figure out what might be a fair amount for her to pay given her circumstances and related to any effort you had to collect it. You guys come back to me with a number. If I don't like the number, I'm going to tell you what it is.
Okay.
Because it seems to me I can talk all day and night long telling you this $5 a day you can't charge. I told you that on Zoom. I'm telling you that today. I'm trying to explain to you why you can't charge it today. You're not listening to me. You're saying it's on paper. That's fine. I don't mind if the agreement between the parties is reasonable. That I don't mind assessing. But this is de facto unreasonable.
Okay, I'll take
to charge her that. And ma'am, understand something. You may want to teach everybody in the world a lesson. That's not your job to teach everybody a lesson. It's not your job to teach them to pay on time or to do whatever. Because sometimes, and I see she's got those two little babies there, she's running around at times to robbing Peter to pay Paul. Because that's just life sometimes, right?
Yeah, I understand.
So you can go out there. It seems the two of you can at least get along and talk.
Mhm.
Come back to me with a number. If I don't like it, I'm going to give you my own number.
So
Because it's
that-
all just 2 months plus a little change that she was behind.
Okay. By the way, there's another portion, and it's security deposit. She started from December 2024, and because I saw her little babies and in the winter, and so I accepted her to move in before the security deposit was paid. So, but it's not paid so far. For
Is
7.
that in this 865?
No, it's separate.
Well, I'm not dealing with the security deposit. Because you got enough problems with the illegal late fees.
Yeah, yeah, but this is also something I need to collect.
You guys go figure out. I'm not dealing with the security deposit. You guys go out.
Okay.
You have to figure out a reasonable amount.
Mhm.
I'll then determine if it's reasonable, and I'll tell you what she's gonna pay on that, and then I'll tell you how she's gonna pay.
Okay, I got a
Give
question.
you guys time to try to work it out.
Yeah, thank you. And I have a question. When can we give you the response before next in person or online?
Oh, you just go out into those little rooms. You're gonna decide this today.
So we can turn in our result to you.
You go out there, you talk. I'll call your case back up, probably first part of the next block. Thank you.
Okay, thank you.
Or recalls case, People versus King, or not People versus King versus McDonald. Why are you leaving them back there? They did well. Come on up. They can come up and sit right up here. They came up, sat quietly. They behaved themselves. I don't know. Well, this one was having a, no, I'm just saying. All right, folks.
You are not.
The parties are here. What did we agree on that I'm gonna tell you I'm probably not gonna let happen?
Let me see. Okay, she said she'll pay the July rent on 23rd. Is that right?
The July
Rent. She's still all the July rent, 520 on 23rd of this month.
Didn't she already pay her July rent?
I counted as July rent, but she meant for July 11th, she paid for June. So that's, she considered as paying June on July 11th. But I thought that was her July rent. So we saw differently, but I count her payment as part of it.
Okay.
Yeah. So I tried to work out July rent. She said she'll pay on 23rd of this month. I accepted. And her last utility bill was $70.86. And she'll pay me after this, or when would you like to? Okay. I appreciated her efforts, and I can cut off her because she paid on June 11th for May rent. That's what she counted for. So I cut off the late fee.
Hold on a second. Ma'am, how much is your portion of monthly rent?
520.
Okay, so of this 865.86 that you told me is owed, you're telling me now that 520 of that is actually rent?
July rent?
No, what she's adding is late fees. She's adding the 50 plus $5 per day. July rent is not even added in here, I don't believe.
But because we're thinking the July rent differently, she thought that was I consider as July rent included, but she considered her July rent should be paid later.
No, something's going on.
No, my checks were being garnished, so that's why I fell behind in the first place. So now I'm playing catch up. So I do need to pay July rent, which I will be able to pay this Wednesday in full. But there is late fees. That is her $850 and something. That's the
so what she technically owes really should be the 520 plus this 860 whatever.
I believe so, yes.
That's what I counted for May, but now I count only for
this should be easy to figure out. Either she's paid July rent or she hasn't. I'm sitting here July, they're doing just fine. Leave them alone.
Okay.
Okay.
I am July rent. So, okay, let me ask you this. Is the reason why we're having a problem as to whether or not July rent is included is because she's taken some of that money for late fees?
I don't agree with the late fees. I think I should be charged one late fee per month.
Well, I'll get to the late fees. But when I sent you guys out, you told me her July rent was paid, that the only thing that she owed is this amount. And then we broke it down to where there was $125, basically, because she had the utilities of the 7086 and then the $55 court costs. And that took 125 off of that. Then I asked a very specific question of whether or not whatever was left was late fees. Remember me asking that?
You're so clear-minded. I thank you so much, Honor. And I counted May rent was not paid, but she counted her May rent was paid on June 11th. That's what we get together when we were in the courtroom. And we figured out, okay, I accepted her as June 11th paid the May rent. But prior, I thought the May rent was not paid at all so far. So that was the difference. So she counted as paid on July, that's 1.5 months later, paid May rent. And then another 1.5 months paid June rent. Then now she's paying the July rent. So I do accept her, explanation, I do. So right now we clarify it as her May rent and the June rent has been paid, but just late. And her July rent will be paid next Wednesday. So I agree with that. We kind of communicated for this.
So I don't care how you put these numbers in. How much are you claiming she owes?
I just cut off her portion as late fee. So I accept your advice. I would charge only $150 for May rent late and $150 for June rent late.
You're not getting $150. Now, ma'am, you're charging her a late fee.
Yeah.
That is, if you charge $150 per month, potentially for her late fee, it's almost a third of what her portion of the rent is.
But she was 1.5 months late. How can I manage my property with all this late fees? I mean, all this late, I have to pay tax on time. My tax is pretty high, much more than the rent. So I need to pay off my tax.
Right. And you could also end up owing money if you were charging an illegal late fee. Yes, legally you could.
But I didn't charge illegally. It's based on the lease that $50 initial charge and $5 per day. That's the agreement.
You're gonna pay your rent on the 23rd, 24th?
Yes, sir.
Get it paid by the 25th. So she's gonna pay her July rent by the 25th. There's gonna be then a decision on the $865 of late fees for 3 months. I'll give that decision August 1st, 2025 at 12 p.m. So I will give you my decision as to what late fees can properly be charged to her. And it's going to be nowhere near that figure. I'm letting you know that right now. I'm going to give you an opportunity because you keep pointing to the lease. You might want to go speak to an attorney. Because if I have to come back and make this decision, and I'm not saying that I'm going to do it, there are going to be certain truth in renting issues that accrue to this tenant, and you could potentially end up owing her money.
But I want a number if you could honor.
Pardon?
I'd like to have a number. I don't have idea. How can I manage this?
I can't answer some of that. I can only suggest to you that you may want to go talk to an attorney about what you can charge. I will give you some guidance, and that is that the typical HUD lease, which still has its problems depending on what that person is paying as their portion, will say either $25 to $30 on the 5th, and then $1 per day, which would then be approximately $50, $55 per month as late fee.
How if it's not paid on the month?
Pardon?
How if that is paid after that month or later, even later?
Right. There's a whole issue with your accounting because however you're applying her payments are first in, first out. She may have been behind, and she just told me she was behind because of a garnishment issue. That's fine. But there's a huge difference between somebody facing almost $740, I guess, late fees for that period in time. And if I were the guidance I'm trying to give you of say 50, 55 a month, and are facing $150 late fees, there's a huge difference in that. In particular, where somebody's rent, their portion, which you figured out by a calculation, is 1/3 of her income, basically about 1/3, that you're going to then charge an additional amount of housing costs. That makes no sense. It is, and quite frankly, I'll just tell you right now, it's unconscionable that you would try to charge them. You're not out every month when she doesn't pay on time. I get it that she should be paying on time. People run into difficulties, but you're not out that entire amount of rent because you're getting a portion of that rent paid. It's her portion that is not being paid. And it's not like she didn't pay it. It's not like she's just bailing. She's just got to figure out how to recoup, get herself back to ground zero. That's all she's trying to do.
Okay.
But she can't get back to ground zero if you keep charging these. She can't get there.
Okay, I accept.
So
Can we?
you guys, no, you guys are going to come back. You're going to get my decision. You need to go talk to a lawyer because you're going to end up in a whole lot of trouble with that lease.
If I agree to reduce
You're going to end up in a whole lot of trouble with that. I'm also going to give her an opportunity to talk to a lawyer if that's what she wants to do in terms of enforcing her rights, because it's illegal. I told you that the first hearing. And then get here and nobody wants to believe me. We'll see you on the 1st. Thank you.
Is that?
Hold on, what? What is it? 3 p.m.? 8-1 at 3 p.m.
Zoom or in person?
It's in person. This one needs to be. Okay?
Will now be on the record in 25 CR 85, State of Kansas versus John Timothy Baker. Please announce appearances.
May it please the court, State appears by Judge-elect Attorney.
William McClendon for the defendant, John Baker, who appears from Greenwood County Jail.
And does he wish an evidentiary hearing, Mr. McClendon?
Your Honor, Mr. Baker and I, we're having a breakdown in communication. I'm going to be requesting a withdrawal on this case.
Well, Mr. Baker, what's the problem?
We're not seeing eye to eye, just the communication is not. I mean, just like you said, I mean, it's just not. We're not seeing eye to eye.
What he's saying, and when he communicates with you, it doesn't make any sense what he's saying. You don't understand language or what?
No, we're not seeing eye to eye.
In other words, he does not think what you're saying will work, and you don't like what he's telling you will work.
That's not at all what I'm saying. That's what I'm saying. What he's saying.
Well, all he says is you've had a breakdown in communication.
That's exactly.
Tell me what would be different if I appointed someone else? Would he have the same problem with that attorney? Knowing you can't read the future, but I mean, you know what the type of problem is. Is it going to be the same wherever whoever's appointed? Mr. McClendon?
Judge, I'm not sure. I do believe we have some stuff in regards to the way case law is read and portrayed, and additionally some factual matters that happened within the case. I think between the two of us, I don't think we get along very well.
Well, some defendants don't get along with any defense attorney and vice versa. Mr. Baker, do you really think a different attorney is going to handle matters differently? You think that?
I
you
have
think
no
that
idea, Your
someone
Honor.
else-
I'm not, who knows? I don't know. I mean, I'm just,
Well, I
exhausting
got
all of
one.
my administrative routes, you know? So, I mean, I'm just
Yeah,
here. There's nothing I can do about it.
what are your administrative routes? What do you mean?
I mean, I'm just seeing what are my possibilities in this case. I mean, as far as my motions to be filed and everything. I mean, I already feel like I've been found guilty of something, and I haven't even been in court yet. This is the first time I've even been in court, and I'm not even in person. This, and you know, we're supposed to be present during all proceedings of court, you know, and I'm not in no courtroom. I don't even know who I'm talking to here, you know. I've got I have 6 different people on the screen here, and I don't know any of them, and I don't know what's going on here. Okay, I've met with him one time, you know, and we're not communicating very well on things, you know.
So you've never been in a court system before? You don't understand how it works? Is that what
I
you're
don't
telling me?
understand how this works. I've been in different court settings, and I've never had a court setting like this right here. I don't see that this is legal.
You've never had a Zoom hearing? Is that what you're talking about?
Not on my preliminary. No, not on preliminary. And from that point on, you're supposed to be present during all proceedings of court, you know?
Well, I don't know that you've missed any yet. I see you have a 2010 involving meth or involving felony drugs and other charges. A 2010,
Yeah,
2015, 2017.
yeah, that's 15 years ago.
21, that's been 4 years ago. 22, that's been 3 years ago.
I've only
25 and a 24, looks like in Reno.
Yeah, all of those are the same thing. Those were just probation corrections and stuff, you know. That's not, I've only been charged one time and got corrections for it. I don't know how it keeps coming up in there like that.
You don't know why only drug
Ever since
charges?
then, it's been 2010. 2010 was the last time I got any charges, and I got brought back in front of the court because I won my appeals.
Here's a 2022 possession of opium, narcotic, or certain stimulant, which is one of your charges today.
Yeah,
Possession
and
of marijuana.
I just don't see how 2 people can be in possession of the same thing. I don't understand that. That's not.
Here's what I think, Mr. Baker.
Mhm.
I think that you're going to probably have the same issues with any attorney that you're having with Mr. McClendon.
But how do you know that?
And because Mr. McClendon doesn't generally have these problems with his attorneys.
He's only had a practice law for 3 years. How does he know that too?
Oh, he's only practiced for 3 years.
Yes, and the only cases that he's won is 2 misdemeanor cases, and they were bench cases. So how is he capable of representing somebody like me, an A-box felon, 3-time convicted A-box felon? There's 10 and a half hours on my body cam, and none of it's been went over. I mean, he's good. I don't deny that he's not a good lawyer. I just don't think that he's the right lawyer for me. We're not communicating correctly. I have motions that I want to file too, you know? I mean, I have a right to a fair trial. I have a right to defend myself in this, you know, and I just don't feel like I'm not bad mouthing him at all. He might be a great lawyer, you know what I mean? I don't know, but I just know that we're not communicating correctly. You know, it's just going to cause conflict, you know, and I'd just rather just not do the conflict, you know. I just don't want any conflict in it whatsoever. You know, maybe the next person might be better for me. Maybe they won't. Who knows? I don't know. I want what's best for me though, you know.
Have you ever had this problem with any of your other lawyers that you've had over the years?
No, I haven't. No, I haven't. Never.
Okay.
Look it up. I haven't.
Do you have an attorney now in your Reno County case from 24?
What case? That's all gone. That's not. There's no case.
One.
Oh, is that for the misdemeanors?
Well, usually municipal courts are misdemeanors. Is that still
Yes.
ongoing?
I have a court, and I've also missed 3 court dates since I've been in here. Nobody has contacted that court, and now I've got 3 more warrants because I've been in here and I wasn't able to make those court dates. You know what I'm saying? So I mean, I don't know what's going on here, but I just feel like my hands are tied behind my back. I've got 3 more warrants now, which have jacked my bond up significantly. No bondsman want to even bond me out. You know what I mean? I don't understand the system here. It's not. I wasn't able to make those court dates. And I was out on bond on those, and I was making all my court dates. I've never had a failure to appear. I don't know where they get the failure to appears at. I've never had a failure to appear. If I did have a failure to appear, wouldn't no bondsman mess with me there at all? Because that's the main thing is failure to appears. They don't mess with that. I'm not a flight risk, you know. I mean, I'm unable to make this bond because of those court dates, because of those failure to appears, which I was in here and I was incarcerated here, and I've told the staff here I've been faxing back and forth, you know, my lawyer
But I have a lot of people that need to be heard today.
right.
And I am going to allow Mr. McClendon to withdraw.
Okay.
And if you just have a personality conflict with your next attorney, you're going to be stuck with that attorney. So try to get along with that attorney.
It's not that we're not getting along. It's just we're not seeing eye to eye. He might be a great lawyer. I'm not bad mouthing him at all. He's probably good at what he does. You know, I don't think he's right for me.
Mr. McClendon appears in front of this court multiple times every week, if not every day. And as you said, he's been doing it for 3 years.
Well, from what I was told, yeah.
I don't typically see people come in here and question his knowledge of the law.
No, but you asked me the question.
Stop. If you talk to him and listen to him like you're doing me, I can see where the problem is.
But you asked me the question.
I think he's making a statement, sir. Now just stop talking and listen for a minute. But you want a court-appointed attorney. We don't appoint attorneys that we don't think are competent and qualified. And just because you don't think his education or his experience is as good as yours, I'm not going to just keep appointing attorneys. Stop. But I will give you one more shot at that, a bite at that apple. So Missy's going to have to find someone that may or may not meet your specifications.
That's fine.
The test is whether the attorney meets the court specifications, but I'm not going to leave Mr. McClendon in this position where you doubt his ability to represent you and his interpretation of the law. Missy, you probably won't know for several days who will take the case, correct?
At least a week.
All right.
Okay.
I'm going to set this over till our next PHC, and then that attorney is going to need time to get discovery and to study the file and visit with you. And so we're going to take some time here.
Yes, ma'am.
When's your next date, Missy?
That August 15th at 1:30.
August 15th at 1:30. If we can find an attorney available, August 15th at 1:30.
May I ask a question?
Go ahead.
Okay, so like I was saying about the me not being able to show up for court there in Reno County because I guess they don't have Zoom or whatever. I don't know what the issue is. I haven't really got too much communication through that. I've asked but so it has raised my bond up. I mean, to where I can't make that bond, and I know that once I bond out from here, I'll be going to Reno County. And I'll be taking care of those there, which I'll probably get an OR bond on those there, but I would like a reason. Ma'am?
Sir, do you mean Reno County or the city of Hutchinson?
Yes, ma'am.
You mean both?
Ma'am?
There's a difference between city court in Hutchinson and Reno County District Court. Which one are you referring to? Because I think you have both by now.
No, I just got a municipal. It should be just municipal court.
All right, I'm going to to tell you this, that is not my court. I have no authority on that.
I understand.
have no say on
But
that.
I haven't asked a question yet, though. What I'm saying is there any way possible that we can make this reasonable, my bond reasonable for me, so I can get that taken care of too? I mean,
I'm not changing your bond.
okay.
All right, we're in recess. Mr. Baker is remanded to the custody of the Greenwood County Sheriff. You may go, sir.
They want you next. I don't want to say. Your Honor, would we be able to do Wilkins next? He's causing some issues with us.
That'd be fine.
Okay. Let's go. Find out. Hopefully.
Find out. How do you find out? Right here?
Yep.
Okay. Oh, shit.
All right, are you Marshall James Wilkins?
Yes, I am.
All right, we'll go on the record in state of Kansas versus Marshall James Wilkins.
Yes,
Case
sir.
number 25 CR 231. The state appears by Darren Deviney. Mr. Wilkins appears in custody from the Butler County Jail. Now, you're here for a first appearance, Mr. Wilkins. There is one charge. It alleges that on August 29th, 2023 in Butler County, Kansas, you unlawfully obtained control over a check in the amount of $3,788.13 with the intent to permanently deprive.
I can't hear, bro.
Hey, are you able to hear me, sir?
I can't hear.
Do you need you can't hear because you need a hearing aid? Or the volume's not loud enough for you?
Or the volume don't fit or something. I don't understand what the deal is.
All right, well, you've been charged with stealing a check from Bestmark Express, Inc. That's theft, a level 9 non-person felony. The value being $1,500, but less than $25,000. Do you understand your charge, Mr. Wilkins?
No,
Okay, what don't you understand about it?
I don't understand the two different charges.
There's just one charge.
Which one is it?
Theft.
Theft?
That's correct.
So what did I steal?
A check.
A check.
Correct. With
So
the
that's
intent
been
to
the check?
deprive
Was the check already
Bestmark-
written? Was the check already written?
I couldn't tell you that, Mr. Wilkins.
Then maybe I didn't steal it.
All right. Can you afford to hire an attorney?
I cannot.
Do you wish to apply for court-appointed counsel?
Yes, please.
All right. Are you currently employed?
What?
You have a job.
Do you work?
Man, I can't even hear out my ear.
All right. I'm going to
When do I
appoint.
get to hear out my other ear?
Hey, Mr. Wilkins, I'm going to appoint James Watts to represent you. He's an attorney here in town. They'll give you his contact information.
When did they stop letting me use my other ear?
Why don't you turn the other way?
Man,
All right, your case has been assigned to Judge Satterfield. She's already set a bond at $4,000 cash.
my bond is $4,000.
That's correct.
Oh,
Your
wow.
next hearing date is on her felony preliminary hearing control docket on September 15th at 2:30 p.m. and that will be conducted by Zoom. All right, Mr. Deviney, is there anything else we need to do with Mr. Wilkins's case?
No, Your Honor.
Can I get this half? Can I get
All
this?
right, Mr. Wilkins, you are excused.
What is this?
Good afternoon.
Tasha, Your Honor.
Are you Anastasia De Los Santos?
I'm Anastasia De Los Santos.
All right, we'll go on the record in state of Kansas versus Anastasia De Los Santos, case number 25 CR 327. State appears by Darren DeVinny. Ms. De Los Santos appears in custody from the Butler County Jail.
I'm just being detained.
You're here for a first appearance. There are 2 charges, both alleged to have occurred on July 16th, 2025 in Butler County, Kansas. Count 1 alleges that you knowingly obstructed or resisted Sergeant Jeffrey Knoll, law enforcement officer, during the process or execution of a warrant, writ, or a process or order of the court. That's interference with law enforcement. That's a Class A non-person misdemeanor. Carries a maximum penalty of a year in jail and up to a $2,500 fine.
Your Honor, if I may, I didn't resist from that gentleman. He put me in handcuffs and told me I was being detained.
I don't want you to make any statements that might incriminate yourself.
Well, I'm not sure who that gentleman is, really.
Count 2 is a charge of possession of paraphernalia for use, the Class B non-person misdemeanor. The alleged paraphernalia items are 2 broken glass pipes with burnt residue. The Class B misdemeanor carries a maximum penalty of 6 months in jail and up to a $1,000 fine.
There's not the court I'm at.
Ms. De Los Santos, do you understand your charges?
No, because I wasn't being charged with anything. I was being detained while they were, I don't know, doing what, because they came there on a eviction, but they couldn't evict me, okay? And I do fund that, okay? And I don't want it destroyed, and I don't want IROC rebuilt. Okay, so that's where we stand.
Come again?
Okay, I don't want the apartment complex destroyed and IROC rebuilt.
All right, Mr. DeVinny, I'm in receipt of a mental health screen. Has the state received similar document?
I've looked at, I think we have received that. I've looked at that. I know that the defendant was screened for evaluation for care and treatment, but did not qualify. So the concern at this point that might be ongoing would be one, assuming she has counsel appointed to look at competency with regard to how it is that we proceed. But I think she's been ruled out for care and treatment.
All right. I do have concerns about competency to stand trial. I'm going to appoint Attorney Darren Patterson to represent you. They'll be able to give you his contact information. What do you want to do about bond, Mr. DeVinny?
Your Honor, the defendant accurately already reported she was given a notice of eviction. She resisted arrest at that point. She was found with drug paraphernalia. That's the basis of the second charge. We do have information. She's also on felony bond for an aggravated burglary at this point in 25 CR 225. Did have a failure to appear, but that was back in 2014, some time ago, for a misdemeanor theft conviction back again 11 years ago. So my recommendation is a $5,000 cash or surety bond at this point.
She has a pending felony burglary charge in our jurisdiction.
Felony aggravated burglary charge, yes.
All right, Ms. De Los Santos, anything you want to say regarding bond?
From his apartment that he wanted me to remove.
Is there anything you want to say regarding bond? Where would you go if you were able to make bond?
Well, actually, I was already given an OR bond.
I don't believe you were in this case.
I already had an OR bond. I didn't go ahead and sign it.
I'm going to set bond in the amount of $10,000 cash or
No,
surety.
you're not. You're going to let me go.
That is not correct, Ms. De Los Santos. I've
Okay,
set
but
bond.
I already had an OR bond, sir.
Well, if you did, you no longer do. Your new bond
No,
is
I do.
$10,000 cash or surety. Your court date is,
No.
I'm going to set
Okay,
this
I'm not even at this
on
court.
the
Okay, this court
expedited
hasn't even happened.
misdemeanor control
As far as
docket.
I'm concerned. No,
August, Ms. Delos Santos, have a seat. Have a seat, Ms. Delos Santos. I'm going to find you in contempt if you don't have a seat immediately, if not sooner. All right, Ms. Delos Santos, I'm finding
you're
you
not giving
in
me that big
contempt
ass,
of
huge ass
court.
bond because I already have one.
I've given you the bond and I'm about ready to give you 30 days in jail for contempt of court.
Okay, but I already have that bond. I already have a bond.
Your court date is on the expedited misdemeanor control docket on August the 1st, 2025 at 1:30 p.m. with Judge Lee. Your attorney will be present with you at that time. All right, Mr. Davini, is there anything else we need to do on this case?
No, Your Honor.
All right, Ms. Delos Santos, you are excused. Have a good day.
It's to me. I get my bond, right? That I already have.
Okay.
Are you Brooke Hitchcock?
Yes, I am.
All right, we'll go on the record in State of Kansas versus Brooke Ashley Hitchcock, case number 21 CR 428. State appears by Darren Davini. Ms. Hitchcock appears in custody from the Butler County Jail. Looks like there's been a long history on this case.
Yes, sir.
Most recently, there is a failure to appear on March 5th, 2025.
Can I explain to you why I wasn't in court, please?
Go ahead.
Whenever I was released from jail last time, I was staying with my mom and we were staying in a house that was infested in mold. So her health started to deteriorate. And now she's actually on hospice and has found out she has lung cancer and stomach cancer, as well as had a cluster of strokes, which we think was all stemmed from the house with mold. And I'm not trying to put that all off on that, but whenever you have something going on with somebody you love very dearly, it's very distracting. I wanted to consume myself with my time I have with her. You know what I mean? Like I wasn't trying to avoid it completely. Whenever I talked to Kit Russell, which is who they appointed me as my probation officer, he told me that he didn't understand what the judge had ordered, and so that he would get back to me. And he told me to report back to him by a certain date. I called him, and they said that was my probation officer anymore. So I tried to follow up with it a little bit, and then my mom's health started to deteriorate, and I got very distracted. But he told me, he told me to stay out of trouble whenever I met with him, and I did. I have not gotten in any trouble in this whole time.
All right, this is a warrant to show cause, is it not, Mr. Davini?
It is, Your Honor.
Okay. It's been alleged that you violated your probation.
By not showing up, yes.
Okay, the three allegations in the warrant are that you failed to make payments on fines and costs, that you failed to report as directed, and you failed to complete a drug and alcohol assessment.
I actually did complete my drug and alcohol assessment.
Okay, well, that's something that you'll be able to.
Communicating with them would probably help for them to know that, yeah.
Yeah, I'm going to reappoint Darren Patterson to represent you. Bond's already been set at $2,000 cash or surety. Do you think you'll be able?
I can't make that. Is there any way you can OR me out, please?
No.
Please, my mom is sick.
$2,000 cash or surety is a very reasonable bond for somebody who failed to appear at their last court date. So.
But what if I go straight to the probation officer after this? Because I was already told I would have a different one. Like I need to be out with my mom. She was put on hospice on Tuesdays any day. Like, please, I really don't have the money, or I would have already made my payments, and I would be making gas to get down here. Please reason with me.
No, I'm setting bond at 2,000 cash or surety. I'm gonna put your case on Judge Lee's expedited misdemeanor control docket, August the 1st at 1:30 PM. That'll be done by Zoom. If you do make bond, I'm gonna order that you contact the probation office. And it'd be a good idea to contact Mr. Patterson's office as well.
Okay, thank you.
All right, we'll be in recess. Have a good day.
Next matter is State of Kansas versus Sai Jones. Case number 25 CR 17. If counsel would state their appearances, please.
Jerry on behalf of the state.
Your Honor, Darren Patterson appear on behalf of Sai Jones. Mr. Jones does appear from the Butler County Detention Facility Zoom screen. Judge, this is a case where pursuant to plea negotiations, he is going to plead guilty to count 2, driving while suspended, second, Class A non-person misdemeanor, and also plead guilty to count 4, speeding 93 and a 65, and other counts dismissed. At the time of sentencing, Your Honor, there's an agreed recommendation on count 2, driving while suspended second, of a $100 fine, court costs, court determined attorney fees, probation fee, 120 days controlling, and a 1-year reporting probation with a standard conditions as well as a special condition that he is to write an apology letter to law enforcement in this case. And then on count 3, scheduled fine. Or that was count 4, I apologize. Count 4, scheduled fine.
Okay, so it's count 1 and count 4.
Count 2 and count 4.
Oh, 2. Okay. And Mr. Regier, is that your understanding of the agreement?
It is, Your Honor. With regard to the special condition of writing an apology letter to law enforcement, this is a case where the affidavit appears to be signed by an affiant who identifies himself as being with the Butler County Sheriff's Office. Additionally, notwithstanding the plea deal currently before the court, count 1 of the information appears to be one count of interference with law enforcement, and that is the basis of the request of the special condition of probation.
All right. Mr. Jones, have you heard what the attorneys have told me?
Yes, I have, Your Honor.
Have you had enough time to discuss this with Mr. Patterson?
Yes, I have, Your Honor.
Do you understand that with a plea of guilty, you would be waiving your right to trial?
Yes, Your Honor.
And do you understand that while there can be recommendations from the parties, the court is not bound to them? On a Class A misdemeanor, you could be ordered to pay, ordered to serve 1 year in the county jail and a fine not to exceed $2,500.
Yes, Your Honor.
And that's a fine solely on count 4. Counsel, you said that was 93 and a 65?
One moment, Your Honor.
Yes, Judge.
All right. It looks like a $177 fine unless there is a work zone or school, those special conditions. I don't see anything that indicates that's accurate or correct. All right. Do the parties stipulate to the factual basis?
Would so stipulate, Your Honor.
I do find there's a factual basis based upon the affidavit in support of the complaint information and the stipulation. Are there any statements that counsel would So I do find that the plea is knowingly and voluntarily entered with the advice of good counsel. Mr. Jones, did anybody force or coerce you in some fashion to enter this plea?
No, sir.
Are you under the influence of any medications or intoxicants at this time?
No, sir.
Anything that makes it difficult for you to think clearly?
No, sir. The only thing is my mom, they just diagnosed her with MDS and they're giving her a month left to live. So, I mean, I'm pretty sad about that right now, but I think I'm thinking clearly.
I do find that the plea is knowingly and voluntarily entered with the advice of good counsel. Factual basis, I already made that finding. I will hear sentencing recommendations at this time if there's anything additional.
Nothing further from the state, Your Honor.
Just briefly, Judge, I would tell a court on his current driver's license status. He's still suspended, but it's only because of one Greenwood County charge or traffic case that he needs to take care of. After that, he would be on a restricted license for a DUI issue.
Okay. Is he okay? Was his license suspended because of the DUI?
His license is currently only suspended because of the sanction D56 from Greenwood County Courthouse case that he has to resolve. He's on restricted on the DUI charge.
Okay, so the parties agreed that the mandatory jail time isn't applicable here, other than the 5 days.
That would be the state's understanding, Your Honor.
Yes, that it does not apply, Judge.
Okay. All right. Mr. Jones, is there any statements that you'd like to make before I pronounce sentence?
I would do anything. I would do probation, community service, anything, just not to be in jail while my mom dies.
How long have you been in jail now?
Judge, the jail records show he was checked into jail June 11.
Mr. Jones, is that the longest you've served in jail before?
Yes, Your Honor.
Are you on probation on anything else right now?
No.
Counsel, what is the apology that's being sought in that letter? For lying about who he was, or to the man whose identity he was trying to use?
Specifically, Your Honor, pursuant to plea negotiations, there would be an apology to the Butler County Sheriff's Office for the events of the incident of January 14th, 2025.
All right. Mr. Jones, is there anything additional you'd like to state before I pronounce sentence?
I'm really sorry about lying about who I was. I definitely won't be writing a letter of apology to him.
All right. In regards to count 4, 93 and 65, I impose a fine of $177. That's the scheduled fine. Looks like this was on 400 at 6:45 in the morning. Where were you going, Mr. Jones?
I was heading to work.
Why so fast?
I was passing a semi going down the hill right there before you go into Leon.
Eastbound or westbound?
I was heading eastbound.
Where is it you work?
Douglas, Kansas.
What's your job?
It's mobile home services. We work all over the place. We work in Oklahoma, Nebraska, Wichita, everywhere. wherever there's a mobile home park.
It says that in the affidavit that you had 4 open suspensions at that time. One of the oldest being back from 08, but also 2009 and 23.
Right. Those have been dropped.
And it also had a non-extraditable warrant out of Tennessee. Is that taken care of?
That was for the false name that I had given.
Well, he said, okay, so was that under the name that you were given? They were the person that had the arrest warrant?
Yes.
That's what you're telling me?
Yes,
Why
sir.
would you use somebody's name that had an arrest warrant?
I didn't know he did. It's my coworker. It was a stupid thing. I panicked and just gave a coworker's name, and I had no clue what past he had. It was stupid. And that's why I'd definitely be writing a letter of apology. I've already apologized to my coworker for it.
As a young attorney, I had a client once who one of his coworkers had taken his license and was using it and would pay it. And I can't remember how many hours I had to try to get that fella's driver's license squared away because of that guy who was using his identity. You seem to have a pretty good familiarity of how to work this.
I don't understand what you mean by that, sir.
Well, I think you understand the system pretty well and how to try to avoid it. Using a real person's name and driver's license.
I didn't have his driver's license or nothing. I just gave him a name.
All right, so those suspensions that I mentioned, were those the other guy's suspensions or yours?
They were probably his suspensions.
Yeah.
What did
Yeah,
you?
Judge, I have his certified driving record from when this case originated, and it does show there are 4 sanctions. But as I review those, it appears one of those is the restriction on his driver's license. And then the Greenwood County case I was telling the court about just a minute ago, and then 2 others that he's already resolved. So basically just one currently, a Greenwood County case.
And you said that was on a DUI?
No, that appears to be subsequent. The DUI was in 2019. That's 2019 CR 181 in Greenwood County.
Okay.
Subsequent to that appears just to be a traffic citation that he hasn't resolved.
All right. Mr. Jones, are you on any sort of probation at this time?
No, Your Honor.
Do you have any other pending cases?
No, Your Honor. All
right, so count 4, I sentenced you to $177 fine. That in regards to count 2, the driving while suspended second or subsequent offense. I'm going to impose a $100 fine. I'm going to impose attorney's fees, court costs, and I will order that you write an apology letter, an appropriate apology letter. I'll address who's got to review that here in a moment. All right, Mr. Jones, 2 things. I already told you the one case that reminded me of, and the other is of an individual that was on a stolen motorcycle with an 18-year-old girl in the back running from the cops, at speeds similar to what you're talking about here at 93. I used to practice in front of a judge. He said, when you get up to that speed, you're not driving the car, you're aiming it. And I'm familiar with that section of road, and it isn't safe to do that.
Right. You're absolutely right, Your Honor.
You got a curb coming up and people coming in, eastbound or westbound. I'm going to impose 1 year in the county jail. I will place you on reporting probation for a period of 12 months. I will give you credit for the time that you've served. It'll be a standard probation for Butler County. You'll report as directed. Mr. Jones, I'm going to put it just flat out. You violate the terms of your probation, and you're going to spend the whole year.
Thank you, Your Honor.
Because you could have very easily killed anybody on that road.
Yes, I know.
And you're not a kid. You know, you've had this issue with your driver's license for a while. You know, there's no excuse for this.
You're right. You're absolutely right.
I'm sorry about the situation with your mother, but I tell you what, you know, I've met with enough people who lost loved ones in traffic accidents caused by behavior like this that, well, I'm just not making, you know, like I said, I'm granting you the probation standard terms. You'll need to follow, be in compliance with all of those. You can be processed out today after your court appearance is done. If you need to contact court services today and get lined up, and you'll have your reported, give you a reporting time. The attorney's fees are $250. Probation fee, as the standard probation fee, I believe, is $60, but whatever it is there. I will order that apology letter. Court services will have to be sure that it's appropriate, and if it is, it can be forwarded on. If the sheriff's office want it or not, court services will contact them about that, but apparently they're wanting it. But counsel, is there anything further I need to address?
Not from the state, Your Honor.
Nothing further.
Thank you, Your Honor.
Well, Mr. Jones, I hope you take me at my word on that, because I will remember this case.
Yes, I promise.
Very well. Good luck to you. And
Thank you.
This case is adjourned. He can be processed out. Is State of Kansas versus Jean Esther Murphy, 22 TR 2680. If counsel would state their appearances, please.
Jeremy here on behalf of the state.
We have Ms. Murphy.
You should be getting seated here pretty quick, Judge.
Okay.
Your Honor, Darren Patterson appearing on behalf of Jean Murphy. Ms. Murphy does appear from the Butler County Detention Facility. Judge, in this case, there are certain plea negotiations entered into. Pursuant to those plea negotiations, count 1 speeding is being dismissed. Ms. Murphy will enter a plea of no contest to count 2, the registration violation. At the time of sentencing, there is an agreed recommendation of a $50 fine, court costs for the court to determine court-appointed attorney fees, a 10-day controlling sentence, and a 6-month non-reporting probation. Thank you. And Judge, just for the court's information, jail sheet shows she's been in jail since July 9.
All right. And you say count 2 is operating an unregistered vehicle or with expired tag or plates?
Yes, Your Honor.
Mr. Regier, is that your understanding of the agreement?
It is, Your Honor.
Ms. Murphy, do you understand that? Well, have you had enough time to discuss this with Mr. Patterson?
Yeah.
Has anybody, do you understand that with a plea of no contest, if you'd be found guilty if I find that there's a factual basis?
Yes,
And you'd be waiving your right to an actual trial?
yes,
All right. Do you understand that while there's recommendations to the court on count 2, counsel, is that an unclassified misdemeanor or a B misdemeanor?
State understands it is an unclassified misdemeanor, Your Honor, although.
So that, all right, an unclassified misdemeanor, the maximum penalties are 30 days in the county jail and a fine not to exceed $500. Not going to say that's what the sentence will be, but that will, that's what the maximum penalties are. You understand that while there's recommendations from the parties, the court's not bound to those. You can be sentenced to the maximum sentences.
yes,
And with those things in mind, are you still pleading no contest to count 2?
yes,
All right. Does counsel stipulate to the factual basis?
We would stipulate that there is a factual basis for this charge, Your Honor.
Okay. How long has their license or had this license been expired?
Your Honor, the ticket in this matter appears to refer to a stop occurring on August 27th of 2022. And the court comments do appear to indicate a suspension of approximately 2.5 months prior.
And Judge, we have ran a driver's license status check, and it shows that as of July 17th, she is valid.
Okay. Ms. Murphy, well, I do find there's a factual basis that there's plea is knowingly and voluntarily entered with the advice of good counsel, and I find her guilty to count 2 on the registration violation, unclassified misdemeanor. Count 1 is dismissed with prejudice pursuant to the agreement. I'll hear any statements that counsel wish to make at this time on sentencing if they so choose. Mr. Begier.
Your Honor, this might be somewhat after the fact, but the state understands or accounts for the defense on the record that the defendant intended to enter a no contest plea. I'm not sure if the court wishes to for me to supplement the factual basis, at least on the issue of jurisdiction.
Based upon the stipulation, I think we covered that.
And I have nothing further, Judge.
Nothing further from the state in that case, Your Honor.
Ms. Murphy, is there any statement that you'd like to make for pronouncements?
no,
Ms. Murphy, with what you were charged with, I really have a hard time understanding why you didn't just show up and take care of things. It shows here that you failed to appear.
okay, I can explain.
Hold on, let me count this up here. Okay, I show 5. Somebody called and indicated, they were family and that you suffer from dementia. Is that correct?
What? I don't have any family here except for my daughter, and she certainly wouldn't say anything like that. I'm an accountant, for crying out loud.
Mr. Patterson, any reason why in your conversations I need to be concerned with that?
Judge, I have viewed her on video on previous hearings as well as met with her at jail. I don't have any concerns about her mental status.
Okay. All right. Well, it's a note that somebody called and said that, and I, of course, with a phone call, I didn't take the call, but it does reflect that you failed to appear 5 different times, and that's why you had the bond and why it didn't get modified.
Okay, they sent those warrants to the wrong address. That's why I didn't get them. I never received them. When my sister got the one delivered to Choba Obj in Cedar Woolley, Washington, she downloaded it, texted it to me, and I immediately called the court. Immediately. I never got, They were delivered to where I used to live, and that trailer park has been vacated and is turned into commercial property. It's no longer even there.
Well, ma'am, how those things are normally dealt with when somebody fails to appear and a bench warrant's issued and there's a bond that's issued, when a person gets picked up and they're given, they sign off on a bond, they're given a court date. And so I don't see how this could, all of your 5 appearances couldn't, with that excuse that you're given in regards to
5.
Yes.
I didn't know about any of them until I talked to the bail bondsman in Independence. That's the first I knew of it.
Well, the file reflects that you failed to appear on November the 2nd of 22. There's a $500 an OR $1,000 OR bond was approved. Then you were supposed to be in court March the 20th of 24. So a year and a half later, thereabouts, 500 cash or surety. Then you were supposed to be there on July the 15th of 24. They continued it to.
I never got notice of any of those. Not a one. The place that was delivered to no longer exists. And I told the patrolman the night that he gave me that ticket that was no longer going to be a valid address, that it was turned into commercial property and no one lived there anymore. And he said it wouldn't matter. Famous last words.
Judge, I apologize for interrupting. Would the court allow a brief breakout room?
Yes.
Thank you.
I'll take you think 5 minutes will be enough?
Absolutely.
Okay, we'll take a 5-minute recess so there can be a breakout.
Thank you, Judge.
Okay, we're back on the record now in State versus Murphy. The appearances are as before. Mr. Patterson, is there anything additional?
Judge, no, I just had a discussion with her about her bonds and that she signed them and there were court dates on the bonds. She does remember having those bonds. She doesn't recall why she didn't appear in court, though.
Okay. Very well. Ms. Murphy, is there anything else you'd like to tell me before?
No.
Since, all right. In regards to count number 2, I'm going to impose a $50 fine, court costs, attorney's fees in the amount of $250.
God love you.
Oh, I'm not done. Yeah. But thank you. I have kind of standard speeches I give in regards to different things, and I've said on so many occasions on this registration, I've never given anybody a jail sentence on that yet. So in 5 years on the bench, you're going to be the first. And I'll give you 5 days. I will give you credit for the time you've served. I find that you've served your time. So
God love you again.
Well, hold on. You need to get these things taken care of financially.
I'll pay it today.
All right. I'll give you 30 days to be sure that it's paid.
I'll pay it today.
Well, again, sometimes there's records and things that need to get caught up. But,
so they might not have the paperwork ready for me to pay it today?
Right. That's what I'm concerned with. So
wait till Monday?
Please just hold off on talking yet.
Okay.
So I'm going to give you 30 days to get it taken care of. Based upon the failure to appear situation, please, write it down, talk with your daughter or whoever you need to in regards to that so that they can remind you and get that taken care of, okay?
So I have to appear again?
No.
Okay. Just be careful.
I just want to
be sure.
Because what will happen is if you don't get it paid, then they're going to suspend your driver's license.
Right.
And then you get picked up and then it's a whole driving while suspended things. I don't know if you've been watching all the other court we've had today, but
no.
It can really get to be a problem for a person, expensive and a lot of jail time. So
Question, will they have this paperwork ready Monday afternoon?
I don't know. I hope that it will be, but to be honest, I'm not on that end of it. And the clerks take care of it.
So how will I know when it's ready? for me to pay?
Contact them on Monday and tell
Okay.
them about the case.
Butler County,
The clerk and
clerk of the district court?
correct. Jen, is there a particular clerk she needs to ask for?
Tell her to ask for the traffic clerk.
The traffic clerk.
Okay.
And if that doesn't work, contact Mr. Patterson or show up at the courthouse. Give it if you're going to do that, wait a few more days. I don't know how fast the paperwork gets done. It's Friday afternoon, so sometimes it takes a little while.
Can't do it today.
Okay.
Yeah.
So, but
I will pay it as soon as I can. I mean, as soon as they get the paperwork ready.
Please just wait for me to finish and we'll be done. Okay, so please, so you can be processed out and released. You got somebody picking you up?
Yes.
Okay, good. All right. Anything further, counsel?
No, Your Honor.
Very well. I will, this matter is adjourned and she can be processed out. Thank you. All right, next matter.
Sorry, Your Honor, just to make sure, no probation?
No probation.
All right.
She served her time.
Thank you.
State of Kansas versus Laura Wells, case number 25 TR 1720. Is Ms. Wells in custody? So this, let the record reflect that the parties have returned all oral or present as earlier stated. Are there any announcements in regards to Ms. Wells?
Yes, Your Honor. Pursuant to plea negotiations, I would announce this time that Ms. Wells will enter a plea of no contest and no proof of insurance. State has agreed to dismiss the remaining charges. At the time of sentencing, there is an agreed recommendation for a $300 fine, court cost, court to determine court-appointed attorney fees, a 120-day controlling sentence, and a 6-month non-reporting probation.
All right. From the notes, it appeared there was a concern concerning competency, Mr. Patterson, that anything on that you feel court needs to be aware of?
Judge, I would tell the court that I've reviewed video from the stop. I've also watched I had watched the first appearance. I've also met with her at the jail. I can tell the court that there was an outpouring of emotions versus a mental health issue, so that she was unable to communicate because she was so emotional at first appearance. And I met with her now, and it appears that she understands what's going on and I don't have any concerns, Judge.
Okay, but all right. Mr. Regier, is Mr. Patterson correctly stated the terms of the agreement?
That is the state's understanding, Your Honor. Based off my notes to somewhat echo what the court has already referred to, my notes indicate that there were certain concerns expressed at the first appearance hearing under KSA 223302. However, given what counsel for the defense has indicated on the record today, if the court is prepared to proceed, the state is likewise prepared to proceed.
All right. Ms. Wells, is that correct that you're going to be entering a plea of guilty to no proof of insurance?
Yes, Your Honor.
Do you understand that that is a Class B non-person misdemeanor? While there's recommendations to the court's not bound to those recommendations. On that offense, a person can be fined up to $1,000 or no more than $1,000 and receive up to a 6-month jail sentence.
Yes.
I'm not saying that's what the sentence will be. It's just that's what the maximum of the law allows. Okay. Do you understand that with a plea of guilty, you'd be waiving your right to a trial?
I do.
And Judge, it was a no contest plea.
Oh, no contest, excuse me. Okay, you understand that with a no contest plea, you're not admitting to the violation, but you're also not challenging it, and you're waiving your right to a trial.
Yes, Your Honor.
And I would ask counsel what the facts would be, and generally, a lot of times it's the affidavit in support of the complaint, but if there's a factual basis, I would find you guilty. Is that a yes?
Yes, Your Honor.
Okay, this is being recorded, so I understood what you were trying to tell me with nodding your head, but please, if you could give a verbal response, it's helpful. Okay, very well. Have you had enough time to discuss this with Mr. Patterson?
Yes. Yes, sir.
Have you, are you under the influence of any medications or intoxicants at this time?
No, sir.
Is there any medications you're supposed to be taking and haven't been?
No, sir.
Okay. Anything that makes it difficult for you to think clearly?
No, sir.
Has anybody forced or coerced you to enter this plea?
No, sir.
Very well. Counsel, is there a stipulation to a factual basis or the affidavit support?
We would stipulate to the court having the affidavit for purpose of factual basis, Judge.
All right. I do find that there's a factual basis based upon that, and that the plea is knowingly and voluntarily entered with the advice of good counsel. Further, Ms. Wells has been responsive, appropriately responsive to the court's inquiries. And Mr. Patterson's a very experienced attorney, and he's met with her and he's expressed no concerns in regards to competency. So I don't see that competency as an issue based upon my observations and findings here today. So I do find the defendant guilty of that one count. Remaining counts are dismissed with prejudice. And is there any additional statements that counsel wish to make before I pronounce sentence?
Not from the state, Your Honor.
Nothing further, Judge.
Okay. Ms. Wells, is there any statement that you'd like to make before I pronounce sentence?
No, no, sir, Your Honor.
Ms. Wells, are you from Butler County, or what's your circumstance?
I'm not. I'm actually from Norman, Oklahoma.
Okay. All right. I'm going to impose a $300 fine. That's a mandatory minimum. I will impose a 120-day jail sentence as the parties agreed. I will place her on a 6-month non-reporting probation with the conditions that she take care of the financial obligations on this case and no new law violations. There's court costs. There won't be a probation fee. I will assess a $250 attorney's fees. And court costs, so looks like we're looking at $458 if I added it right. No, $558. Yet again, this is why I don't do math in public, folks. $658. Am I getting that correct now, Mr. Patterson?
Judge, I really wasn't even doing that one, so I can't check you. Sorry.
Okay, $300 fine, $250 attorney's fees, and $108 for court costs. If I'm adding that up correctly, and clearly I wasn't before, but $658. How long is it going to take you to get that taken care of, Ms. Wells?
And I do a payment plan and break it up into 2 payments.
That's why I'm asking how much time you're going to need.
2 months.
Okay.
I pay half on the 1st of August.
Here's what I'll do. I'm placing you on probation, so you can be released after we're done with court. I want you to get it paid within 120 days.
Okay. Okay.
That's 4 months. So it's best to get these, so you'll need to contact the clerk of the district court and get the information of what you need to do to get it paid off, or, where you need to send it, and that they'll tell you the methods that you can do that. Because I know they accept electronic, people can pay electronically now. So go ahead and do that. And so the conditions of your probation is to take care of that within 120 days, and also no new law violation.
Yes, sir.
Be sure that your vehicle is insured. I don't know if I'm assuming you have an Oklahoma driver's license. I don't know Oklahoma law if they're going to ding you on your driver's license or not, but be sure that they have a current way of contacting you, so that if there's a penalty there, you can get it taken care of, so they don't suspend your license. Okay.
Okay. Yes, sir.
Any questions? Okay. Good luck to you. This nothing further. This matter will be adjourned. She can be processed out.
Oh my. Ladies and gentlemen, what am I to say after all of that today? It's been a long show, almost 3 hours. We're currently at 2 hours, 51 minutes. Ladies and gentlemen, it's been a pleasure to bring you these cases. I am your lone wolf Usul, and we do this every Saturday for an indeterminate amount of time every Saturday. And we always start around noon Eastern time, but you can't wait another week for a live show. Come on by. Every weeknight, about 9 p.m. Eastern, we have a premiere where we have a live chat running, and all these wonderful chatters are hanging out with us. We're chatting about the cases of the day. Come on by and hang out with me every day here on the channel, and keep an eye out for other cases that I'll drop between these little lives mirrors that we do over here. Ladies and gentlemen, I am your curator for this channel, and I am your host for this here weekend review. I am your lone wolf Usul, and I am tired. But I have to say thank you to all of you. In particular, I definitely want to say thank you to Rhonda, Mantle, Zach. Zach made it to the top 3. Are you kidding me? Thank you, Zach. Cat, Metal Rules, Tev, Brominicus, Patrick, all the people whose names I can't really say, all the things I really can't think to say. Rhonda, thank you very much for your donation earlier today and that super sticker. Manta Maker, thank you for your donation. And the puppies, definitely thank you. And Zach, hit me up later and I can tell you how to get one of these wolf DMs if you really want one. Yeah, that's a thing. I mean, it's a thing. Thank you all for supporting the channel. Your support is greatly appreciated. Thank you all to everyone who's come by and lurked, chatted, everything else. Oh, Cat, I see you. That's a super sticker. Thank you so very much. It helps out a ton. As a matter of fact, that's going to get the puppies treats this afternoon. Absolutely. They're picking up an order. Kids, signing off. Y'all have a great afternoon. I'm your lone wolf Usul. I'm out.